If you or someone you love is facing a felony charge, the cost of a lawyer can feel almost as scary as the charge itself. So let's answer the big question first. There is no one fixed price for a felony defense attorney. A simpler felony case may cost several $1,000s up front. A serious case, a complex case, or a case headed toward trial can cost tens of thousands of dollars or more. That is not meant to scare you. It is meant to help you slow down and ask better questions before you sign anything. This is general information, not legal advice. Prices depend on your state, county, charge, evidence, prior record, attorney experience, and whether the case ends in a plea or goes to trial. And one of the biggest mistakes people make is assuming the quoted price includes trial. A lot of times, it does not. One felony case might cost a few $1,000s, while another can cost more than a car. A felony is usually more serious than a misdemeanor. It can involve prison time, probation, fines, immigration problems, job problems, housing problems, and long-term record consequences. That means the lawyer is not just showing up once and talking to the judge. They may need to review police reports, body cam footage, surveillance video, phone records, lab reports, or digital evidence. They may need to attend hearings, negotiate with prosecutors, file motions, prepare witnesses, investigate facts, and get ready for trial. Criminal defense fees vary based on case complexity, attorney experience, and location, and felony cases usually cost more than misdemeanors because the stakes and workload are higher, according to NOLO. The cost can also depend on the charge, possible sentence, prior convictions, whether the person is detained, how much evidence exists, and whether experts or investigators are needed. So the fee is not just for one court appearance. It may be for weeks or months of work. This is where the same dollar amount can mean very different things. Some lawyers charge a flat fee. That means one set amount for a defined part of the case. But defined part is the key phrase. A flat fee might cover pretrial work, plea negotiations, certain hearings, or sometimes the full case. It does not automatically mean trial is included. Justia notes that criminal defense lawyers may charge hourly fees or fixed fees for a case or a stage of a case, depending on the arrangement. Other lawyers bill hourly. That means the total depends on how much time the case takes. If the case gets complicated, the final number can grow. Then there's a retainer. A retainer is money paid up front. If the lawyer bills hourly, they may draw from that retainer as work is done. If the balance gets low, they may ask for more money. NOLO explains that criminal defense lawyers often require money up front before starting work through this kind of arrangement. A retainer does not always mean the whole case is paid for. Also, criminal defense is not like an injury case. A lawyer generally cannot take a criminal defense case on contingency, where you only pay if you win. The ABA model rules prohibit contingency fees for representing a defendant in a criminal case, under Rule 1.5. So do not only ask how much, ask what exactly does this cover? Trial is where the price can change fast. Many felony cases resolve before trial, but if the case goes to trial, the work can increase sharply. Now you're talking about trial preparation, jury selection, court days, witness preparation, motions, exhibits, records, transcripts, investigators, and sometimes expert witnesses. Some sources give examples where a felony lawyer may ask for several $1,000s up front, plus a separate daily trial fee. NOLO gives one example of about $3,500 in advance, plus about $1,000 per trial day as an illustration. That is only an example. It is not a national price rule. Some cases cost less, some cost much more, especially serious felonies, federal cases, violent charges, sex offense cases, or cases with heavy evidence. There may also be costs beyond attorney fees. These can include investigators, experts, transcripts, records, travel, and technical evidence review. Expertise.com lists case expenses like investigation, expert witnesses, transcripts, records, and travel as possible additional costs in criminal defense cases. That is why a lower quote is not always cheaper. If it excludes trial, experts, or major expenses, the final cost may be very different. So before anyone signs, ask, what stages of the case does this fee cover? Is trial included? If trial is not included, what would trial cost? Are experts, investigators, transcripts, records, and travel included or billed separately? What happens if the case ends quickly? What happens if more court dates are added? Is there a payment plan? Will the agreement be in writing? Who will actually appear in court? If you cannot afford a private lawyer, ask the court about appointed counsel or a public defender immediately. The Bureau of Justice Statistics describes public defense as legal representation for people charged with crimes who cannot afford private counsel in cases involving possible imprisonment. Eligibility depends on financial need and local court rules, and the court may ask for financial information under oath. A public defender is a real lawyer. Public defender offices can be busy, so communicate clearly, show up, bring paperwork, and ask questions. So, how much does a felony defense attorney cost? There is no single fixed price. A simpler felony may start in the low thousands. A serious, complex, or trial-bound felony can reach tens of thousands of dollars or more. Before hiring anyone, ask what the fee covers. Ask whether trial is included. Ask what costs are separate. Ask what happens if the case changes, and get the agreement in writing. If private counsel is out of reach, ask the court about a public defender right away. If this helped, like this video, subscribe to Fresh Start Society, and visit freshstartsociety.hq.com for more information.